Mr. Pappas, Senator Pappas, go ahead.
May I have privilege of the floor?
Please do.
Thank you. Ladies and gentlemen of the Senate, today, March 25th, 2021. Does anyone know the significance of March 25th? How about March 25th, 1821?
Now you're making it harder. Give us a little help.
200 years ago today. Charlie was there. Well, let me tell you, exactly 200 years ago from today, March 25th, 1821, marks the commencement of the Greek people's successful struggle against the tyrannical occupation of the Ottoman Empire. So they began their struggle for independence today, 200 years ago, and it culminated successfully, thank God, in the Greek state that you know today as Greece. And so in honor of their bicentennial, I asked the governor to issue a proclamation, and I would like to read that to the body and to the people of the great state of Wyoming. If I may, Mr. President.
Please do.
Governor's Proclamation, Greek Independence Day. Whereas on March 25th, 1821, the Greek nation began its struggle for independence from the suppressing rule of the Ottoman Empire, which enslaved its people since the fall of the city of Constantinople in 1453. And whereas the Greeks valiantly waged war against their Ottoman oppressors under the brave leadership of Theodoros Kolokotronis for almost 9 years, and whereas the War of Independence was formally concluded in 1832 with the signing of the Treaty of Constantinople, creating the borders of a modern independent Greek state. And whereas ancient Greece developed an advanced civilization unlike any the world had seen, shaped modern society by originating the concepts of logic, science, lyrics, philosophy, and history, developed the concept of democracy in which the supreme power to govern was vested in the people, and inspired the notion of participation in government, which influenced the framing of the United States Constitution. And whereas March 25th is celebrated as Independence Day in Greece and in Greek communities around the world, commemorating the beginning of the War of Independence, and whereas it is my honor to recognize all past and present Wyoming citizens of Hellenic descent for their contributions to the educational, social, moral, and economic principles that are so deeply ingrained in the fabric of our state. Now, therefore, I, Mark Gordon, Governor of the state of Wyoming, do hereby proclaim March 25th, 2021 as Greek Independence Day. In the state of Wyoming, I urge all Wyoming citizens to join me in saluting the people of Greece and the Greek diaspora on the 200th anniversary of Greek independence, and publicly encourage our citizens to reflect upon the contributions of the Greek community. And in witness thereof, I have hereunto set my hand and caused the great seal of the Governor of Wyoming to be affixed this 17th day of March 2021, signed Mark Gordon, the Honorable Mark Gordon, 33rd Governor of the great state of Wyoming. So, ladies and gentlemen, please, I actually proclaim you all a Greek for a day. So please help me. Please. So I was going to say, please help me wish all the Greeks happy birthday, 200 years.
Happy birthday. Very good.
Thank you, Mr. President.
Thank you. I've traveled to Greece to watch a wrestler in the Olympics from my hometown. Enjoyable country. All right. We'll continue now with third readings. We moved this out of the consent file and put it in numerical order down in with third readings. House Bill 76, third reading of the House Bill.
House Bill 76, Uniform Statewide Payment Processing, sponsored by Representative Brown, an act relating to the administration of government.
There are no amendments. House Bill 76, Senator Rothus.
Thank you, Mr. President. Mr. President, without objection, I'd ask that House Bill 76, Uniform Statewide Payment Processing, be laid back for 1 day so I can contemplate an amendment.
Absent objection, it'll be laid back 1 day. House Bill 76. House Bill 121, third reading of the House Bill.
House Bill 121, state-funded capital construction, sponsored by the Appropriations Committee, an act related to state-funded capital construction.
Senator Perkins.
Thank you, Mr. President. I'd move third reading amendment number 1 to House Bill 121. Excuse me. Is it
Let's
House Bill
acknowledge, let's have him read in the
Oh,
amendment.
Thank you.
That's okay.
House Bill 121, third reading amendment number 1 to engrossed copy, section under consideration, addition to sections.
Now yours, Senator.
Thank you. At this point, Mr. President, I'd move third reading amendment number 1 to House Bill 121 and ask the body's favorable consideration. Mr. President and members of the Senate, what we did in the second, this relates to the amendment we did in committee of the whole. And what we did is we took the projects for the community colleges, which are the CWC Jackson Outreach Center, the Northwest Student Center, the LCCC RAC renovation, the Northwestern Community College Construction Technology Center. And then there was also an authorization of the University of Wyoming that authorized them to for up to $25 million for the design and construction of a new College of Law. And what we did is we moved those out, and I just moved them out into a separate paragraph and had them enumerated. And it's important for the purposes of this amendment, Mr. President, to note that all the community college construction projects are in paragraph A. Or in subsection A, subsection A. And so that's those projects I just listed. It's the Jackson, Northwest, the Student Center, the RAC, and the Construction Technology Center. So when you're coming back to the amendment, Mr. President, and you look, so under B, we have for purposes of subsection A, which are these community colleges, we had authorized them to proceed and they could do whatever they want to do with private funds. And so what this amendment does is simply, as you see, it says we're going to redefine private funds as is in the bill as it currently is, to may include federal funds from qualifying capital construction grant funds allocated to the state under section 604 of the Coronavirus Capital Projects Fund of the America Rescue Plan Act. And so the state construction department may, and the way that works, Mr. Chairman, is as we talked about in this particular act, there's $109,600,000 set aside for construction projects in the state of Wyoming. And under that act, they're to remain available until expended for making payments to states, territories, and tribal governments to carry out critical capital projects directly enabling work, education, and health monitoring, including remote options, in response to the public health emergency with respect to coronavirus disease. So what we have there is we have an opportunity and the way these work is these funds in the capital construction don't come directly to the state. They have to be applied for. You have to demonstrate that your projects come within the confines of the capital construction. And so what this does is simply define that so that if these community colleges go out and they would qualify to use some of the capital construction money from this federal act, that then the state construction department may apply for it. And if received, then it can be used to build those structures. That's what this does. It simply expands that and gives us the opportunity to take advantage of some of the very specific provisions in this act for our community colleges. And so obviously, if we get $1 federal, it's $1 less of these other private funds that have to be used. And that's what the amendment does. I would encourage you to support it. And with that, Mr. Chairman, I'd stand for any questions. Thank you.
Questions on the amendment, Senator Scott?
Mr. President, the dollar for dollar reduction Mr. President, I think we might be getting in trouble with that. The reason is I've seen instances in the past where you take federal money, you take a bunch of federal requirements, and they are significantly expensive. And a building built with strictly private money I've seen cases in the past where the federal requirements increase the cost so much that if you do a dollar for dollar reduction, you may not have enough money to construct the project. You might have to take only a dollar federal money may only relieve you of 50 cents worth of private money because of the increased federal restrictions. The particular project I have in mind, it turned out the extra expense of taking the federal money was so high, you're better off not to do it at all. If that's the case, well, then you simply don't accept the federal grant. But if it's a mixed situation where the extra costs of doing business for the federal government, say, increase the amount to where you can only take half as much as you get off the private, I think we may be getting in trouble with this amendment. And I'd like to hear some discussion on that. I wish it wasn't third reading because I think this amendment may get us in trouble in a way that could be fixed if we had a little more time.
Further discussion, Senator Pappas?
Yeah, just one explanation, Mr. President. As I read it, however, we don't have to take the funds. It's may, correct? So we would, I think, at the time, know the restrictions and the requirements, because a lot of projects won't have federal strings tied. Some will. So with the way it's written, I don't think we can get into trouble because we should be able to know those restrictions prior to accepting.
Senator Grew?
Thank you, Mr. Chairman. And as the fact of this being a third reading amendment is something we've been talking about a lot. And we're going to talk about it some more with another bill that's coming up. We know more about the federal guidelines that are coming out today than we did yesterday. Certainly more than we knew a month ago, and not as much as we're going to know tomorrow. So in other words, we have to go with the best information we have now because we're here now. In addition to that, there's a good chance that we're going to be here later and we can make changes as we go in a special session when we'll know more then than we know now. So all this is doing right now is trying to cover the bases at the moment and the best we can, and then give us the opportunity not to lose out, but also give us the opportunity, as the last speaker, my good friend next door said, that we can back out of. Thank you, Mr. Chairman.
Senator Kinski?
Thank you, Mr. President. On and for the amendment. So to add just a little bit more background to this, you know, a number of us, including my district, have projects that have been long delayed. And we've been working to get the projects in the can. And I've urged them, you know, make sure you've got the projects on hand, make sure you've got your match. And the authorization in 121 originally said, what we want to build is a 50,000 square foot light manufacturing training facility for industry and the community college and high school students, and with an incubator for entrepreneurs. Because in my area, we're not trying to diversify. We are in the manufacturing business. And so this is critical to take us to the next level. So the original authorization said, we're not going to give you any money, but we authorize you to build it if you can go find the money through private funds. And it literally said private funds, private revenue. Well, now this latest enactment from Washington comes out. There's $104 million in there that says for critical capital construction for critical projects, education, healthcare, or work. That's all it is. And so, at least in my case, my hospital and my community college, and probably yours as well, would like to have a chance to submit an application, if not all of that money, for a match on it. And that's all this language is doing, is saying, because you have to have authorization from the state to build it, even if you build it with private funds. You have to have authorization from the state to build it, even if you're going to use federal funds. So we're trying to take the authorizations. What we're trying to say is, don't come to us for general fund money, but if you want to fill out an application for this ARP money, go ahead, knock yourself out, get in line, see if you can. And it's the community colleges they're going to have to watch for the strings. And I'm not going to let them mine get in any trouble. I'm not going to let my hospital get in any trouble. But they've got to start working on this now. Now, I assume that at some point we're going to be back down here to ruin our summers, to look at this ARP funding, and we'll have a chance. We'll know more then. If there's strings and it's unacceptable, we can call a halt to it, because I don't think the applications will have been submitted by then. But we've got to be able to enable all of our colleges and our healthcare facilities to start getting ready for this thing if they can. I'm hoping personally, since our local governments are getting a lot of money and our school districts getting a lot of money, that we can get all these folks to collaborate on it. And so we need to have some language that just enables that. So as distasteful as it is to take federal money sometimes, in the end, if we get something that really helps us diversify our economies or helps build our healthcare infrastructure, let's take a look at it. It doesn't hurt to take a look. So this amendment, there might be some strings hidden, but we'll have plenty of time to pull back if those strings later emerge. Right now, as to the construction, it does not appear there are any strings attached, except just whatever critical healthcare, education, and work capital construction means. You know, maybe they'll change their mind later and decide that a manufacturing training facility is not critical, but we'll know more when we're back down here. But for now, I think we really need to have this amendment. Thank you, Mr. President.
Further discussion on the amendment? We're on the amendment. Senator Perkins.
Thank you, Mr. Chairman. Just to finish that off, the good senator from Sheridan, or the not so good senator from Sheridan, however you prefer. Anyway, the good senator from Sheridan was right. And so the reason the Construction Management Division of State Government is in here is there for two reasons. One is that for a number of years ago, we involved them in the capital construction projects of community colleges, because community colleges in some instances need a little bit of help and a little bit of expertise that is available from the Construction Management Division of the state. And the other reason is that unlike the other funds, these funds are set aside, but you have to apply for them. The application has to be approved. And so there's the assumption is that the CMD will be the applicant on behalf of the community colleges. But coming back again, this doesn't implicate general fund. There's not a string tied, at least to the state, for this that we've been able to be aware of. And again, so this will be a decision that local college boards will make. These local community college boards will make. They'll have to analyze with whatever guidance that comes out as they make these applications. Again, you know, some of these may not qualify under the guidance that comes out, but I think some probably will. And they'll have to do this going forward. But it would just seem to us that in trying to get and move this forward, that this is a way to try and broaden that opportunity for some of these community colleges to get some of their projects done. And I think that this would help, but it certainly doesn't obligate. And it leaves it also, it's also permissive with respect to CMD, so that ultimately, even if the colleges don't, but the governor's office or CMD, the executive branch, thinks it's a bad idea because of the strings that are attached, then they don't have to make the application on behalf of the community college. So I think we've got a little bit of ability to control the throttle on this. But these aren't general funds, and again, as the good senator from Sheridan said, it is the opportunity for them to apply and see if they qualify for these funds if they want to move forward with these projects. Thank you, Mr. President.
Ready for the question? Question on third reading amendment number 1 to House Bill 121. All those in favor say aye. Aye. Those opposed, nay. The amendment has passed. Back on the bill, House Bill 121, state-funded capital construction. Any further discussion? Any further discussion? Senator Hutchings.
Thank you, Mr. Chairman. I may get in trouble for this, but I'm concerned, or I have a question on the first, I think it was first reading amendment to this bill brought by our good senator from the Trona County. I noticed in there were all the community colleges were listed, and right in the middle, they're authorizing the University of Wyoming to build the law college project. And I just wanted to get some more information on that. Thank you, Mr. Chairman.
Senator Steinmetz.
Thank you, Mr. President. That amendment was our amendment to take that out of the bill. And so it was put in by the House, and that has been removed from the bill by the Senate amendment.
Further discussion? Senator Perkins.
Just a finer point of clarification on that, that I think if we look at the original bill, that the law college was just like the community colleges. It was authorized if the university could find their own money to build the law college, it was authorized. As the House bill came over from as that's the way it left JAC, as it went through the process, when it came to us in the engrossed version, it had a $12 million appropriation for building that college. And we removed that general fund appropriation. So it's back to the point where if they found private funds to go build that they could go ahead and authorize them to go ahead and build that. So so the bills that as it's constituted now has no state general fund monies or other state monies that go towards that, the law college. It's just, if they have the money, they find the money, they find donors, or if they wanted to build it from reserves or something like that, they could. It's just, it wouldn't be general fund dollars.
Thank you. Senator Hutchings, follow up.
Yes, sir. I just want to thank them for that, because that was pretty much a burden on me seeing that in there, and I just didn't want that to
Cleared
be.
up. Okay.
Thank you.
Thank you. Further discussion? Further discussion? Ready for the question? House Bill 121, having been read 3 separate times, the question is, shall the bill pass? The chief clerk will call the roll.
House Bill 21 roll call, 121 roll call. Anderson. Aye. Baldwin. Aye. Beitman. Aye. Boner. Aye. Bouchard. Aye. Case. Aye. Cooper. Aye. Driscoll. Excused. Ellis. Excused. French.
Aye.
Aye. Murphy. Aye. Guru. Aye. Hicks. Aye. Hutchings. Aye. James. Aye. Kinsky. Aye. Kolb. Aye. Cost. Aye. Landon. Aye. McEwen. Aye. Nethercott. Aye. Pappas. Aye. Perkins. Aye. Rothfuss. Aye. Salazar. Aye. Schuler. Aye. Scott. Aye. Steinmetz. Aye. Wasserberger. Aye. President Dockstader. Aye. Closing vote. Closing. Vote closed. House Bill 121, 28 aye, 2 excused.
House Bill 121, having received the affirmative vote of the majority of the members elected to the Senate, House Bill 121 has passed the Senate. House bills on first reading. House Bill 36, first reading of the bill.
House Bill 36 engrossed, Management Council membership sponsored by Representative Larson, an act relating to the legislature.
House Bill 36 is assigned to Committee Number 12, Rules. House Bill 51, first reading of the bill.
House Bill 51 engrossed, Meat Processing Program sponsored by the Agriculture Committee, an act relating to the emergency expenses of government, passed the House, ayes 56, noes 4.
House Bill 51 is assigned to Committee Number 5, Agriculture. House Bill 127, first reading of the bill.
House Bill 127 engrossed, Public Health Amendments, an act relating to the public health sponsored by Representative Barlow, passed the House, ayes 58, noes 2.
House Bill 127 is assigned to Committee Number 7, Corporations. House Bill 173, first reading of the bill.
House Bill 173 engrossed School Finance Funding 2, sponsored by the House Education Committee. An act relating to school finance passed the House. Ayes 41, noes 19.
House Bill 173 is assigned to Committee Number 4, Education. House Bill 219, first reading of the bill.
House Bill 219 engrossed Investment Funds Committee membership, sponsored by Representative Nicholas. An act relating to the investment of state funds passed the House. Ayes 40, noes 19, excused 1.
House Bill 219 is referred to Committee Number 7, Corporations. House Bill 239, first reading of the bill.
House Bill 239 engrossed Workers' Compensation Student Learner Agreement, sponsored by Representative Greer. An act relating to workers' compensation passed the House. Ayes 59, noes 1.
House Bill 239 is assigned to Committee Number 9, Minerals. House Bill 244, first reading of the bill.
House Bill 244 engrossed State Investment Administration, sponsored by the House Appropriations Committee. An act relating to public funds passed the House. Ayes 43, noes 17.
House Bill 244 is assigned to Committee Number 2, Appropriations. House Bill 253, first reading of the bill.
House Bill 253, Higher Education Ban on Funding for Abortion, sponsored by Representative Gray. An act relating to the University of Wyoming and community colleges passed the House.
House Bill 253 is assigned to Committee Number 10, Labor Health. House Bill 254, first reading of the bill.
House Bill 254 engrossed Transportation Computer Systems, sponsored by Representative Burkhart. An act relating to the funding of government operations passed the House. Ayes 48, noes 12.
House Bill 254 is assigned to Committee Number 8, Transportation. House Bill 263, first reading of the bill.
House Bill 263 engrossed State Coronavirus Recovery Funding, sponsored by Representative Nicholas. An act relating to emergency funding of government passed the House. Ayes 43, noes 16, excused 1.
House Bill 263 is assigned to Committee Number 2, Appropriations. Reports from standing committees.
March
Oh,
25.
wait, excuse me, just a moment. Sorry, Senator Cost.
Mr. President, with your permission, I would like to refer House Bill 179, optional municipal tax election. House Bill 65, political subdivisions deposits. House.
Are you, Senator, are you sending these all to the same committee?
Yes,
All right.
as I was asked to.
I think we should do that individually. Yeah, excuse me.
I was doing all right.
All right, you can do it in one sweeping motion. We've got that decided. Go ahead. Do it again. Say the bill numbers again.
Yes, sir. Thank you, Mr. President. I would like to refer House Bill 179, optional municipal tax election. House Bill 65, political subdivisions deposits. House J,
Joint resolution.
joint resolution, thank you. Mental block. State sovereignty impacted by federal actions if time allows, and House Joint Resolution 9, local government investment in equities if time allows. Obviously, I don't need to read the if time allows, but I did. From number 7, corporation, to number 1, judiciary. And it might be if time allows in judiciary too.
All right. Absent objection, those have been re-referred. Thank you. And folks, you heard us do that right before lunch. We're redoing it for the record while we are broadcasting. So that's why we did that, to bring it back into the public forum. All right, with that having been done, we are now ready for reports from standing committees.
March 25, 2021, Mr. President, Committee Number 7, Corporations, Elections, and Political Subdivisions, to whom was referred House Bill 38 engrossed, Community Behavioral Health Priority Populations. Respectfully report same back to the Senate with the recommendation that it do pass. Ayes, Senators Boner, Case, Driscoll, Nethercott, and Scott. Senator Driscoll, Chairman. March 24, 2021, Mr. President, your committee number 8, Transportation, Highways, and Military Affairs, to whom is referred to House Bill 19, engrossed antique motor vehicles, respectfully reports same back to the Senate with a recommendation that it do pass amended. Ayes, Senators Anderson, Furphy, Landon, McEwen, and Pappas. Senator Pappas, acting chairman. March 25, 2021, Mr. President, your committee number 6, Travel, Recreation, Wildlife, and Cultural Resources, to whom is referred House Bill 115, Big or Trophy Game Animal Minimum Hunting Age, respectfully reports same back to the Senate with a recommendation that it do pass. Ayes, Senators Guru, Landon, Salazar, and Schuler. Excused, Senator Ellis. Senator Schuler, acting chairman. March 24, 2021, Mr. President, your committee number 9, Minerals, Business, and Economic Development, to whom is referred House Bill 102, engrossed, Wyoming Preference Act of 1971 amendments. Respectfully report same back to the Senate with a recommendation that it do pass amended. Ayes, Senators Anderson, Beitman, Cooper, and Rothfuss. Excused, Senator Wasserberger. Senator Anderson, chairman. March 25, 2021, Mr. President, your committee number 6, Travel, Recreation, Wildlife, and Cultural Resources, to whom is referred House Bill 95, engrossed, Game Roadkill. Respectfully report same back to the Senate with a recommendation that it do pass amended. Ayes, Senators Guru, Landon, Salazar, and Schuler. Excused, Senator Ellis. Senator Schuler, acting chairman.
Thank you. Could we have the floor leader step back onto the floor? I did see him behind the bar. Oh, you want to take care of this, Mr. Vice President? All right. Mr. Vice President, we're in that order of business, consideration of bills on general file.
Itself into the committee of the whole.
You've heard the motion. All those in favor say aye. Those opposed, nay. Senator McEwen, you have an opportunity to lead the Senate right now.
Don't screw it up.
It's been amended to decide. And I'll have a list of them up here so you can watch that.
Good, good.
Committee of the Whole, please come to order. The first bill for our consideration is House Bill 64. The reading clerk will read the House bill.
House Bill 64, engrossed, Uniform Fraudulent Transfer Act, extinguishing claims, sponsored by Representative Greer, an act relating to the Uniform Fraudulent Transfer Act. Was referred to committee number 9, which returned to committee recommendation that it do pass. Ayes, Senators Anderson, Beitman, Cooper, and Wasserberger. Excused, Senator Rothfuss. Senator Anderson, chairman.
You have heard the reading of the bill. What is your pleasure?
Light. Mr. Chairman, I move that when the committee of the whole rises to report, to do so with the recommendation that House Bill 64 do pass. And for a great explanation of this bill, I would turn it over to Senator Nethercutt.
Thank you, Mr. Chairman. House Bill 64, Good Senators Uniform Fraudulent Transfer Act, extinguishing claims, is work from our brilliant estate planners in our state that have brought forward this concern and this bill in order to keep Wyoming in the top tier of favored states for asset protection. So this is the work from those great professionals in our state. Asset protection trusts are a vital part of Wyoming's business. They're similar to our LLCs, for Wyoming being a top tier location for these types of trusts for asset protection. And what this does is it continues to make us more competitive. Our surrounding states, or the states that are most competitive with us, their statute of limitations is similar to what is proposed in this bill. And so we're trying to maintain that competitive nature with those states to keep up with those. So we're changing it from 4 down to 2 years, as you can see there in the bill, for the statute of limitations under the Uniform Fraudulent Transfers Act. So there's laws associated with the transfer of assets out of these asset trusts, ensuring that they're not done fraudulently. So we're shortening that time frame for when those claims can occur, and also providing additional language regarding for what a claim for relief should look like under the law. And that's found on page 3, lines 9 through the remainder of the next page. This bill has been worked really heavily by the legal professionals in our state and financial planners also as well, who deal in this space. So with that, I would stand for questions and ask for your favorable consideration. Question?
Call for the question. Question. All those in favor of Senator Anderson's motion to adopt this? All those in favor say aye. Opposed? House Bill 64 passes.
It's an asset protection.
Committee of the Whole.
So people can transfer the assets without
The next bill for consideration is House Bill 112. The reading clerk will read in the House bill.
House Bill 112 engrossed Pioneer Trapper License, sponsored by Representative Clausen, an act relating to game and fish, was referred to committee number 6, which returned the committee recommendation that it do pass amended. Ayes Senators Ellis, Landon, Salazar, and Schuler. Excused Senator Guru. Senator Ellis, Chairman.
You have heard the reading of the bill. What is your pleasure, Senator Landon? Senator Ellis.
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, it do so with a favorable recommendation of House Bill 112. And there was an amendment, and I'd ask that it be read in at this time.
Will the reading clerk read in the amendment?
House Bill 112, Standing Committee Amendment number 1 to engrossed copy, page 2, line 3, delete.
Mr. Chairman, I move Standing Committee Amendment number 1 to House Bill 112, and would ask the body's favorable consideration. This is just a technical amendment that makes some clarifying adjustments, and I think we can dispose of it right now.
Are you ready for the question? All those in favor of Senator Ellis's motion to adopt Standing Committee of the Whole Amendment number 1 to House Bill 112, please say aye.
Aye.
Opposed? Standing Amendment number 1 to House Bill 112 has passed. Back to the bill, please.
Thank you, Mr. Chairman. I'm looking around the room if any of the sponsors of the bill would like to stand up and address it. But basically what this bill does is there are residents that have fur-bearing licenses to trap fur-bearing animals. This would create a pioneer license that would be available to anyone who's over the age of 65. And so the cost of that you'll see included in the bill would be $20. This doesn't affect a large constituency in Wyoming, but there was some strong support from the bringers of the bill, and we did not hear any opposition. So this seemed like a good thing to do with very minimal impact to our state. So would ask for your favorable consideration.
Senator Landon.
Thank you, Mr. Chairman. Just to back up the good chairman, we were told that there were about 41 trappers in the state of Wyoming who have this said license, 65 plus, and this will impact, I think, 29 of them. So we're talking, $580, and I think we can afford it. We thought these guys that are still out there doing it, getting after it, let's give them a little break, and a lot of support for the bill. Thank you.
Question? All those in favor of Senator Ellis's motion that when committee of the whole rises to report that it do so with a favorable recommend. Favorable recommendation of House Bill 112, say aye.
Aye.
Opposed? House Bill 112 has passed committee of the whole. Your next bill for consideration is House Bill 68.
House Bill 68 engrossed, Wyoming Statutory Foundation Act amendments sponsored by Representative Greer. An act relating to the Wyoming Statutory Foundation Act was referred to committee number 9, which returned to committee recommendation that it do pass. Ayes Senators Anderson, Beitman, Cooper, Rothfuss, and Wasserberger. Senator Anderson, Chairman.
You've heard the reading of the bill. What's your pleasure, Senator Anderson?
Mr. Chairman, I move that when the committee of the whole rises to report it do so with the recommendation that House Bill 68 do pass. And for a great explanation of this great little bill, I call on Senator Nethercott.
Thank you, Mr. Chairman. Good senators, you have in front of you more work of those estate planning professionals in our state. Wyoming Statutory Foundation Act amendments. Again, this goes along with the need to strengthen Wyoming's laws and provide conforming amendments to be in best practices and competitive environment for those statutory foundations that we have in this state, a unique type of entity that we have. The bill really addresses some additional flexibilities that we're allowing to be statutorily authorized concerning units or shares concerning a statutory foundation that have to be spelled out in an operating agreement, as you can see on page 10 and going through the next page, what those terms and definitions and requirements are regarding the distribution of some of those shares and whether or not you have to be an original founder of the statutory foundation in order to distribute some of those shares. So with that, I would stand for questions and ask for your favorable consideration.
Are you ready for the question? All those in favor of Senator Anderson's motion that when committee of the whole rises to report that it do so with favorable recommendation of House Bill 79, say aye.
House Bill
68, say aye. All those opposed, no. House Bill 68 has passed committee of the whole. Our next bill up for consideration is House Bill 79. Will the reading clerk please read in the House bill?
House Bill 79 subdivisions sponsored by Representative Duncan, an act related to real estate subdivisions, was referred to committee number 7, which returned to committee recommendation that it do pass. Ayes Senators Boner, Case, Driscoll, Nethercott, and Scott. Senator Driscoll, Chairman.
The committee, you have heard the reading of the bill. What is your pleasure, Senator Driscoll?
Mr. Chairman, I move that the committee of the whole rise to report it do so with a favorable recommendation on House Bill 79. And for further explanation, I call myself. Folks, this is a bill dealing with subdivision, and we're fixing a loophole that we created. If you remember back a few years, we created some family, when you did family splits, you had ways to do it. If you go to the meat of the bill on page 2, goes back to where it's titled, and what we've done is added into it prior to the division, 5 years for land title before February 27, 2019. That was the active date of that bill. And it's for land titled on or after February 27, 2019. And it moves it to no more than 5 years. And then at the last, on line 18, it says for not less than 1 year if the parcel was created before February 27, 2019. Folks, what this does is we created a loophole where there's some people that actually had land transactions that were hung up in a loophole in the law. We had a 5-year deal. They fell in between on it. This cleans it up so that our title is all clear. Everything's done right. And going forward, we're right back to the law the way we did it. I'd stand for questions or ask for favorable consideration.
Are you ready for the question? All those in favor of Senator Driscoll's motion that when committee of the whole rises to report, that it do so with a favorable recommendation of House Bill 79, say aye. Those opposed? House Bill 79 has passed committee of the whole. Our next bill for consideration is House Bill 85. Will the reading clerk please read in the House bill?
House Bill 85 engrossed unlawful dissemination of an intimate image sponsored by Representative Stiff, an act relating to crimes and offenses, was referred to committee number 1, which returned to committee recommendation that it do pass amended. Ayes Senators Cooper, French, Kolb, Cost, and Nethercott. Senator Nethercott, chairman.
Mr.
You have
Chairman.
heard the reading of the bill. What's your pleasure, Senator Nethercott?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report it, do so with the due pass recommendation of House Bill 85, unlawful dissemination of an intimate image. I'll call on myself to explain the bill. Good senators, what this has to deal with is really the increasing conduct or practice of uploading sexual images or pornographic images that might have been consensual to start with, but no longer are, onto the internet or other locations, and recognizing that that is a crime and should be a crime when an individual doesn't have consent associated with the documentation of that intimate image or act. And so there is a standing committee amendment, if I can have that read in.
House Bill 85, Standing Committee Amendment number 1 to engrossed copy, page 4, line 18 after.
I move Standing Committee Amendment number 1 to House Bill 85, and to explain the work of the Senate Judiciary Committee while I was absent, I will call on Senator Kolb.
Thank you, Mr. Chairman. The amendment basically covers some enhancements after a conversation about the potential crime. It was thought that it was appropriate to enhance some of the penalties, giving the judge some more flexibility. And it basically went from 6 months to 1 year for time imprisonment, and the fine went from $1,000 to $5,000 for that dissemination of those images, which the committee thought was an appropriate amendment to this bill. I'll stand for questions.
Are you ready for the question?
Mr. Chairman.
Yes, Senator Scott.
Mr. Chairman, as I read it, what's done is you make it a felony for the second time. My question is, felonies have all kinds of ferocious consequences. Why not make it with, decrease it very slightly and make it a misdemeanor, high misdemeanor, instead of felony?
Senator Cole.
I'll move to divide the amendment. Is it divisible? I'll just divide it. Oh, excuse me. I'd like to divide the amendment.
I rule that it's not dividable.
Can I overrule the chair? Thank you. Thank you for this decisive decision, Mr. Chairman.
Okay. I'll ask. Senator Cole.
I
think
ask for the Rules Committee.
You have to give me the divisions. I need you to give me the divisions, please.
Line is page 1, line 1 to line 12, or excuse me, 11. Line 1 to line 11 for the first division. Second division be line 12 to line 20. Is that correct? Or excuse me, line 17.
That is divisible.
Point of
Yes,
order.
Senator Ellis.
Point of order, I think lines 1 and 2 go with lines 12 through 18, or excuse me, 12 through 19. And the senator can name them how he wants, but I think lines 1 and 2 go with the remainder of the amendment.
Senator Kolb.
Mr. Chairman, I'm agreeable to that change.
Senator Kolb, will you please restate your division with your lines?
Lines 1 and 2. And 14 through 19, Division 1.
Okay. Division 2.
Lines 4 through 13. Excuse me, 11, 4 to 11. Sorry.
Senator Office.
Thanks, Mr. Chairman. Point of order real quick. So just as a procedural, we need to make sure that every line number is included in the sum of the divisions. So for example, it might be the first division, Division 1 would be lines 1 through 3 and 12 through 20, where Division 2 could potentially be lines 4 through 11, so that all of the numbers are included, all line numbers need to be included. Thank you.
I'll restate the division, Mr. Chairman.
Thank you, Senator Kolb.
Lines 1 and 3, and then lines 12 to 20, Division 1. And then lines 4 to 11, Division 2.
Which division do you want to deal with first?
First division, Mr. Chairman.
Mr. Chairman, you'd rule then that you find it divisible and ask him to proceed on the division if you find it divisible.
I find it divisible. You want to proceed with Division 1, Senator Kolb?
Thank you, Mr. Chairman. So to restate Division 1, it enhances the time from 6 months to 1 year for being found guilty of your first offense, and the fine goes from $1,000 to $5,000, and or for that offense. It's Division 2, 4 to 11. Oh. All right, Division 1, I'll restate. That's the dissemination of an image for a second time or more as a felony punishable by not more than 3 years imprisonment and a fine of not more than $10,000 or both. I'll stand for any questions.
Senator Scott.
Mr. Chairman, I renew my question as to why the committee chose to make the second time and subsequent a felony as opposed to just a high misdemeanor.
Senator Kolb.
I'll stand and ask the good Senator Cooper to elaborate on this. Thank you.
Senator Cooper.
I may not be the right guy because excuse me, Mr. Chairman. I may not be the right guy because I'm going to refer to some language we had here a little while ago about felonies and filling the courts up. So I'm not sure I'm in favor of this section.
Senator Cost.
Thank you, Mr. Chairman. The thought was on this, that this is a fairly serious nature, and after somebody's been caught with it more than once, it's necessary to consider something a little steeper than just a slap on the hand or wrist. The necessary idea for this was that by setting up a felony for the second time, people involved with this might think about it a little bit more the next time that they do so. With the fact that it was 3 years with good behavior and the time earned, they can be probably considered on release within 1.5 years. And so therefore, the time's not extremely long. That all depends on what the judge makes for the determination of how long they're going to make the sentence anyway. As for the 10,000, that went up to just moving the 1,000 up to 10,000. I guess that's on the other part though. So anyway, I would stand for further questions if you wanted to address them to Senator Kolb or Senator Cost.
Senator Kolb.
Well, just to clarify, this is frankly a devastating situation for anybody who had this happen to them. And also it would seem logical to believe that they had other issues that for a person that would do this. And it is a terrible thing to happen to somebody. I would say vote it up or vote it down. Thank you.
Senator Hicks.
Down, vote it down, Mr. Chairman. I think that's the appropriate explanation. Here's my concern. You know, where do you tend to see this happen is people that are very young. So think, 18, 19-year-olds, 20-year-olds with the technology and I think this is just a bad policy issue. You're going to capture a lot of young people because of lack of indiscretion and maturity and make felons out of them. And we could fill the prisons up with all those young people too. Just vote it down.
Are you ready for the question? Senator Wassenberger.
Well, thank you, Mr. Chairman. Just having spent 14 years of my life with middle schoolers as a building principal, what the good senator from Carbon County was talking about is absolutely true. So we need to make sure that if we're going to do this, we need to make sure that students under the age of 18 are not a part of this because they're doing this.
Senator Nethercott.
Thank you, Mr. Chairman. Just to provide some clarity and to protect the young men and women of our state. To be clear, this doesn't relate to the division or the amendment, but two pieces of information before we go off on a rabbit hole that I have to recover. One, the bill limits it to 18 and older. Two, we have a whole separate statutory scheme associated with minors and sexting so that they're not felons and proper resources can be provided to their bad behaviors. So just point of clarity there. This is really intended to get to adults who are behaving intentionally, nefariously to the great harm of the victims. That is irretrievable, just to be mindful of the impact of the conduct, but just words of wisdom there.
Question.
Senator Scott.
Mr. Chairman, and that's exactly right. We are talking just about young adults here. Supposedly an older adult could do this, but most of the offenses are going to be with younger adults. And frankly, biology doesn't meet with our minor adult legal distinctions entirely. Up to about the recent research on how brains develop and how maturity develops, people are frequently not fully mature until about the age of 25. And so you have quite a number of them in this younger group who are capable of doing some very indiscreet things. Now, those can be quite harmful, but the effects of conviction of a felony are so much broader than just the jail time and the fine. I think we're better off leaving this category with a high misdemeanor, which is potentially a pretty severe penalty. You can spend up to a year in the county jail. You can have a fairly hefty fine. I think that's more appropriate for this kind of misconduct in that kind of adult but not fully mature age group. So I think we're better off without creating the new kind of felony, additional felony, and I would urge us to defeat this part of the standing committee amendment.
Are you ready for the question? All those in favor of Senator Nethercott's motion to adopt Standing Committee of the Whole Amendment Division 1 to House Bill 85, please say aye. All those opposed? The Division 1 has failed. Division 2. Senator Scott.
Mr. Chairman, I urge adoption of Division 2.
Senator Cooper.
Mr. Chairman, in defense of my good colleague over here, I think this is the appropriate fine for the crime, and I think this is time to move this forward. Thank you very much.
Senator Rothfuss.
Thank you, Mr. Chairman. Mr. Chairman, just to clarify, and I believe this then would be a possibility for the first offense also. So somebody who was 19 years old on their first offense would be apparently eligible for a year in jail and a $5,000 maximum fine. Am I reading that correctly?
Mr.
Senator
Chairman.
Nethercott.
Thank you, Mr. Chairman. So all crimes have to have a jail sentence with them. There's a couple crimes in our statutes that don't. We just eliminated jail time for traffic offenses. Recognizing that this type of crime is not a traffic offense, they all need a jail time period. Typically, jail is very rarely ordered, unfortunately. And so it really is placed on a term of probation. In this case, for a misdemeanor, it would be unsupervised with a small fine. It's a slap on the wrist, quite frankly, probably for the level of harm that's been committed, but I do think it's a good start. So, you know, if you want to make it a crime, then it needs to have a jail sentence attached to it, because that's how those crimes work out. That's fundamental to our criminal code.
Are you ready for the Senator Rothfuss?
Thanks, Mr. Chairman. Again, just to clarify though, my understanding of the amendment is either way, there's going to be jail time. It would be 6 months and $1,000, which is the base jail time associated with a base fine, which is already in the bill draft, if I'm reading it correctly. And that would be enhanced with the amendment from 6 months to 1 year and from $1,000 to $5,000. So we're basically taking this to a high misdemeanor again, potentially for a first offense. Maybe I'm misreading it. That's what I'm taking it as, is an enhancement of even the first time penalties to what's effectively a high misdemeanor. When again, we go back and compare it to other crimes, it seems that we're actually disproportionately increasing this one relative to other offenses. And again, I might be misreading it. My apologies if I am, Mr. Chairman.
Senator Nethercott.
Thank you, Mr. Chairman. A high misdemeanor and a low misdemeanor is a legal fiction that we like to create to make ourselves feel better. But in its application, it's meaningless. You're either convicted of a misdemeanor or you're not. And you're either convicted of a felony or you're not. Other states have rankings, so a Class A felony or a Class B felony. We don't have anything like that. We keep it simple. Misdemeanor or felony. Insignificant as to whether or not it's high or low. However, indulging this body's desire to do that, yes, a judge would have the discretion to do 0 to 1 year or $0 to $5,000. or both. And that's the way our criminal code is written, is to have both the jail sentence and the fine or both. And that's the way it is for every single crime. It has been extended from a limitation of 6 months and a limitation of $1,000 to extend it to a year and $5,000.
Senator Cost.
Thank you, Mr. Chairman. You know, sometimes we got to think a little bit, and I think this is one of those times. We've got an internet out there. We've got all kinds of things that could be thrown out there, and the defamation of somebody becomes quite extent. And I don't think we need to make light of it. I think it's serious. And at some point, we've got to show the respect for whoever's involved and say, no, if you're doing this, you deserve to pay. And I'm sorry if some people think that it's not a big deal if you're 19 or whatever, but it is a big deal. And I think it's our responsibility to make sure they understand that. I just think that a little slap on the wrist for this is not okay. This is a way of the revenge against somebody that you were intimate with at one time and now you're not, and you want to get even with them. That's not okay. And there should be something of a penalty for that. I'm sorry, but I think this is well worth it. I would support too.
Senator Gold.
Thank you, Mr. Chairman. You know, this is a way of giving the judge broader discretion. I think I feel confident that if we give the judge the tools and the latitude, he'll make a good decision. I wouldn't like him to be hemmed in with a situation where hundreds of thousands of photos could have been disseminated and he would treat it like it was a single photo. So it gives him a broad discretion, and I think it's the discretion that will be well used. And thank you, Mr. Chairman.
Senator Office.
Thank you, Mr. Chairman. And the idea that this chamber has that 6 months in prison is equivalent to a slap on the wrist, I don't know where we established that. I don't know if anyone here served 6 months in prison. I know I haven't, fortunately. Hope not to. But the idea that we trivialize that as, oh, well, that's nothing. 6 months in prison. Wow, it's a walk in the park. $1,000 fine, good heavens. Not a big deal at all. I don't know how we got to the point where we think that's trivial, but we really do as a body, right? We consider that a slap on the wrist, as if 6 months in prison would not be a disincentive, would not completely ruin someone's life, would not make them lose their job, cause them all sorts of hardship. It's a significant punishment. It exists elsewhere in statute, and we typically have $1,000 as the maximum for a misdemeanor. $5,000 is, I realize we don't have an explicit definition of high misdemeanor. We tend to use that colloquially as something that is over $1,000 because $1,000 is the typical limit in statute for a misdemeanor. So when we go beyond that, it seems to require some justification on how this then becomes worse than a lot of our other misdemeanors, where again, it certainly does vary. We know that in statute. So, Mr. Chairman, the first thing I guess I would ask for a justification of is how a year as the maximum changes behavior, leads to prevention and reformation in a way that 6 months doesn't. What data do we have? What support? What analysis? What evidence suggests that an outcome at some point will be changed other than the cost to the state of Wyoming for that additional time? Because we assert it. And Mr. Chairman, the second question I have is regarding how this works. This is an intimate image, is the way I see it written, distribution. And so I'm curious for the sponsors, if someone sends out 3 images in the same event, are they initially going to be charged with 3 counts of this and then pled down probably to a guilty plea for 1 count of it? Is that how it's going to play out? Is that allowed? Thank you, Mr. Chairman.
Senator Nethercott.
Thank you, Mr. Chairman. A couple of things. We always focus on the offender in this room, which always shocks me. But that 19-year-old who's probably really 40, the average age of a rapist is 31. Don't know if that's young or old, but their victim is really young too. And the average age of these offenders for the victims is like 15 to 25. What about the victim? What about her? How long do you think it will take her to recover from the action of exposing her intimate parts onto the internet that can never be retrieved or taken down or removed? Think it'll take longer than 6 months? Probably. But I hope he's okay. I hope we don't damage him and he's not inconvenienced by his action and harmed permanently like she probably is. Let's just be clear about those gender roles. More likely than not, that's what's happening. 6 months to a year, if we want to focus on rehabilitation, recovery, deterrence, all of those things that we care so much about, oftentimes that year jail sentence is suspended in lieu of probation. That allows the court the ability to provide or require additional services like anger management counseling or sex offender treatment counseling or whatever may be the case. Although these probably aren't sex offenders, these are somebody who's doing it out of revenge. They're doing it out of malice. They're not doing it out of some type of sexual deviant behavior, although maybe, certainly possible. And so it allows for additional opportunity for that offender to receive treatment. What we know from our criminal justice reinvestment information is that really 3 years is the magic mark for probation. Keep in mind, we can't keep an offender on probation for 3 years on a misdemeanor because it's a misdemeanor and we can't do anything longer than 1 year. That's the limitation between the difference between a misdemeanor and a felony. And so, in this case, it's pretty easygoing. 2 things. I think the year is appropriate to allow for the appropriate level of treatment to occur in the event that that's necessary. And 2, don't forget about the victim.
Senator Cooper.
Thank you, Mr. Chairman. As we looked at this fine and jail terminology, we also looked back at some not dissimilar crimes and what their punishments were. And we found that the 6 months and $1,000 was pretty inequitable compared to what we considered not dissimilar crimes. So we brought the level of this punishment up to the level of was either a similar crime or maybe even a lesser crime. It was under funded, if you will, before. Thank you, sir.
Senator Hicks.
Mr. Chairman, just a little discussion getting back to it, and I do think we need to understand the impact on the victim here, but was there any discussion in the committee at all about, restitution into the victims? There's a fund that we established to help those people, victims compensation fund. Was that discussed as that the court could order so much compensation go into that fund to help with any of those type of activities to treat the victim or compensate the victim? So I'm just curious if that was an alternative that was discussed in the committee also.
Senator Nethercott.
Thank you, Mr. Chairman. In all crimes, the court has the ability to order restitution, which is not the same as levying a fine. A fine is intended to go back into society to balance out the consequences of the conduct. Restitution is intended to make the victim whole, if that's possible. Curious case in this situation. It's not like it's a broken arm, but there's a medical bill that you can say, yep, it costs $700 at the ER. What is the cost to have your intimate parts uploaded to the internet? What is the restitution there? I think that's a very difficult figure to calculate or to understand. But there is the ability always in all of our criminal cases to order restitution. In most cases, in a misdemeanor, this is not always true, but at the felony level, it's a mandatory $250 each time for each crime, automatic. Our victims' compensation fund is robust as a result, and we can really provide those services to many victims in the state.
Senator Rothfuss.
Thank you, Mr. Chairman. I just wanted to respond to the implication that we're not considering victims. Because I do think it's important to recognize that all of these policies at least in my view, require a balance of thought and a balance of consideration. I don't think this body personally has a problem considering that side of things. And I can tell you, I'd prefer not to be standing up and defending the perpetrators and the folks that are going to go to jail, because my sympathy is with the victims. But the idea that a guilty perpetrator of a crime is somehow then not entitled to a balance of justice and appropriate sentencing, appropriate reformation, appropriate prevention, just because we're mad at them, again, is just not consistent with the Wyoming Constitution. So while I think it's tiresome, it's certainly tiresome for me to stand up and give this speech time and again, I believe it's important that we justify each time the sentence that we're giving and don't make it an easy process just because we're mad at them. They've done something wrong. Again, it's not our responsibility and role, in my opinion, Mr. Chairman, to then just forsake them completely, write them off and say, all right, well, you did something which is clearly bad. It's criminal. You were convicted of a criminal offense. So we're done with you and we're going to throw the book at you. It's just not the way we're supposed to do things. So I apologize if somehow it seems that I'm not sympathetic to victims. I think my record in this chamber over the last decade, though, trying to protect people time and again from crime, from offenses, from healthcare concerns, from whatever else, would suggest that I'm probably not just trying to support that 31-year-old rapist, I believe was who I was supporting at that point a moment ago. I'm not. But again, I do think this is excessive. And so I'm on and against the amendment. We'll see where the chamber lands. Thank you, Mr. Chairman.
Senator Scott.
Mr. Chairman, and I'm on and for the amendment because I think that the additional penalty is justified, although I would say that if somebody feels it's too high a penalty on First Amendment, I don't see how you can deal with that in this amendment, but there's always second reading, come back and have a lower penalty on first offense if you feel that that's appropriate. But Mr. Chairman, I have a question for the learned attorneys in the room. Typically, I know we do not have probation that is longer than the prison sentence. My question is that a constitutional provision, or can we by statute, specifically by this statute, if we think 3 years is what's needed to cure somebody of doing this sort of thing, could we impose a 3-year probation term statutorily in general and specifically in this bill, if we thought it was appropriate to give the longer probation term, recognizing that if it gets revoked for violation, the most they could wind up serving would be a year?
Senator Gold.
Well, on and for the amendment. I just like to try to convey the new technology we're talking about. This phone is a portable movie making device and picture taking device. Those images, once they go out on the internet, are not able to be recalled. You know, yeah, you can take them down from a website, but they're forever alive out there. And that image of that person, and I'd say it wouldn't be me or the distinguished senator from the ivory tower they're taking a picture of, is most likely some young lady. Her life has been devastated. Now, I'm not going to tell you that I can truly understand that because I'm a man, but I will tell you, I know what'll happen. I know it'll be a fact. And we're dealing with a new age technology. We're dealing with a new reality here. And we're obviously going to have to probably look at how this works out in the long run and find out maybe there needs to be more penalties for these type of crimes, because the impact that you have on an individual, you can't even come to grips with that. I mean, I don't think we really know, because how about 20 years? You're a young person and that image still's around. You go to a job interview. Hey, there seems to be an image of you here. What do you say about this? How do you explain that? The embarrassment, the humiliation. I think I really don't have words for it, but I think this is a step to address that, and we allow the judge to make that decision. And I think it's our best foot forward at this point. And thank you. I urge you to vote for this amendment.
Senator Perkins.
As the not so learned attorney, to go back and answer the question that was asked, I don't think there's anything that's constitutionally prohibits having, if you wanted to have a year a year of imprisonment or 6 months of imprisonment, and then you have a longer term of probation. I don't think there's anything that constitutionally prohibits that. What happens is just human behavior catches up with it, and it becomes a matter of practicality. Do I just, do I just bite, so I go to jail for 6 months, and then I don't have to deal with it for 3 years. And you find that all the time, and that's one of the reasons why, it's a little bit further afield, but it's indicative and I think illustrative of this situation. One of the problems you find in prison as you're trying to get people to parole is they will just simply refuse to even apply for parole, because they'll just want to, quote, slam is the term, slam their sentence and be done. And then they can walk out the door and they're a free man or a free woman, and they don't have to worry about it. Nobody gets to look over their shoulder. Nobody gets to tell them what to do. And so, and there's been times I remember on Judicial Committee, we actually came back and we extended sentences. We actually made certain sentences longer, because what we found is the feedback from the therapeutic committee was, unless these people are, you've got to have a longer therapeutic period for these folks, or you can't require the therapy that they need. And the other thing that I think people need to understand also, it's a counterintuitive of the fact that pretty much the recidivism the results of whether, quote, you're cured, whether or not you recommit, it's a really pretty close to whether you do it voluntarily or whether you're forced to do it. There's not a whole lot of difference in those numbers. So you can do that, but it's just, you got to get that, it's hard to get the Goldilocks sentencing provision in to make it just right. And so it's just, as a practical matter, there's a lot of people out there who will just not agree to a longer sentence. And it does happen with some misdemeanors as part of the plea deal. They'll agree to a longer period of probation because they really, really, really don't want to go to jail. And even in some cases, if you remember, we talked about the 501s earlier, that where you get your one shot at the apple. Even as a part of that, sometimes even that they'll agree to kind of supervise, or to at least, go to sensitivity training or go to substance abuse training, or whatever was kind of the root cause of what caused them to commit that crime or contributed to the commission of that crime, to get those issues resolved. And so it's just really as a practical matter. But one of the problems you have when you have a sentence of less than 6 months, by the time you get them in and get them seen, 6 months just does not provide enough time for them to get the therapy or the assistance that they need. And so I think one of the reasons that I'm going to support this amendment is just because that longer period of time is important, to give a fair chance to have an evaluation and have these people maybe figure out the damage that they did when they did what they did, as well as, if they've got some other thing going on, to get some help with that, or maybe they did it in a moment of, maybe it's a result of some substance abuse or some other emotional problems or other things like that. They can help get some they can get a chance to get those things resolved before they're free of that supervision again. So anyway, thank you. I think hopefully that answers that question, and thank you, Mr. Chairman.
Are we ready for the question? All those in favor of Senator Nethercott's motion to adopt the Standing Committee of the Whole Amendment number 1, Division 2, to House Bill 85, please say aye. Division 2? That's what I said. Oh. Those opposed? Standing committee member,
We're really not supposed to interrupt votes, and there's a deal about the rhythm and everything. Can you just start over and redo the vote?
all those in favor of Senator Nethercott's motion to adopt Standing Committee of the Whole Amendment Number 1, Division 2 to House Bill 85, please say aye. Opposed? Standing Committee Amendment Number 1, Division 2 has passed Committee of the Whole. Let's move on to the bill. All those in favor of Senator Nethercott's motion that when Committee of the Whole rises to report, that it do so with a favorable recommendation of House Bill 85, say aye. Those opposed? House Bill 85 has passed. Committee of the Whole. Our next. Senator Driscoll.
I request the committee of the whole stand to ease the sound of the gavel. Folks, we're gonna go caucus down in W110. We'll gavel back in after caucus. We'll take 5 minutes and then we'll meet in 110. Republican caucus, thank you.
Chairman, recognize.
Senator Giroux.
Oh, thank you, Mr. Chairman. The Democratic Freedom Caucus will be caucusing right over there in the break room. There'll be free donuts and drinks. So you're all welcome. Thank you.
Committee of the whole, please come to order. The Committee of the Whole, please come to order. First bill for our consideration is House Bill 101. Reading clerk, will you read in the bill?
House Bill 101 engrossed, an act relating to elk feed grounds, elk feeding closures requirements, sponsored by Representative Summers. Was referred to committee number 6, which returned to committee recommendation that it do pass amended. Ayes Senators Ellis, Landon, Salazar, and Schuler. Excuse Senator Guru. Senator Ellis, Chairman.
Senator Hicks, you've heard the reading of the bill. What's your pleasure? Senator Ellis, you've heard the reading of the bill. What's your pleasure?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, it do so with a favorable recommendation of House Bill 101. There's a standing committee and I'd ask that it be read in.
House Bill 101, Standing Committee Amendment number 1 to engrossed copy, page 3, line 4, delete.
Mr. Chairman, I move Standing Committee Amendment number 1 to House Bill 101. And for an explanation of the bill and the amendment, I would defer to Senator Hicks.
Senator Hicks.
Mr. Chairman, this good little bill deals with the closure of elk feed grounds. The state of Wyoming currently operates somewhere around 21 to 23 elk feed grounds in the western part of the state. There's been a lot of pressure to close those for various reasons. And on a couple occasions, it looks like some of these are on federal lands and they may lose their permit to feed elk on those. So what this does is go through and it establishes a process for how those elk feed grounds would be closed. But right now, it's totally at the discretion of the commission. This brings in a little more input. So if I just walk you through the bill real quick on page 2, closure. This only deals with permanently ceasing operations or closures by the department. But before that happens, they have to have a recommendation that they would provide to the governor. And before the department, Game and Fish Department would provide that recommendation, they would have to coordinate and consult with the Wyoming Livestock Board. We go into Romanet I. Once the commission provides the recommendation to the governor, then the governor would decide whether to go ahead and close those feed grounds. We go over to page 3, Romanet 2. This just brings in the commission and the Livestock Board. Must have a public meeting located in a location that's relatively close to where that feed ground would be closed. And then goes on down in the lower section of that and says the commission shall compile those comments and submit those to the governor with their recommendation. Subsection B, this deals with any temporary closures. Those would still be eligible to do. Governor the order would be by the governor. For emergency purposes, could close those on a temporary basis, but not exceeding 6 months. You go over to page 4, Mr. Chairman. This brings in subsection C. It doesn't provide an option that the commission, if one of them was decided to close either temporary or permanently, the commission is authorized then to contract to lease private lands for the purpose of relocating those elk feed grounds. We go into subsection D. This deals with federal lands, and if there is a closure on federal lands, the department has to report back to the TRW committee. And this is in a case that they know that they're going to close them. The feds won't reissue a permit for them. And then under that report, report would require to the TRW contingency plans. We'll bring in the standing amendment here in a minute. And then just any other lands that may be owned by the commission or the state of Wyoming or private lands for those supplemental purposes where they could establish a feeding operation if it was needed. Mr. Chairman, it just goes into page 5. This just brings in some of the definitions and then not definitions, but in this subsection, continuation of the authorization of feed grounds will include commencing and ending annual feed. This just is a provision that says nothing in this statute interferes with the normal operations of those feed grounds. Bottom of page 5 brings in the Livestock Board. And it just says convene when necessary for the purpose of considering recommendations. Those recommendations would come from the Wyoming Game and Fish Department on any closures of elk feed grounds. Mr. Chairman, next page, turnover, powers and duties. This is the commission. And this just brings in this statute under their current or it brings in under the Game and Fish Department, this new statutes that created in the bill. Mr. Chairman, on the standing committee, most of this is just cleanup languages or clarifications. So page 3, line 4. This just establishes that the commission is the lead agency and the livestock board and that the commission will consult with the livestock board. It's the same thing in page 3, line 5 and line 13, deals with clarification that the department consults with the livestock board. And then on page 4, line 15, it just adds that as part of those plans that would be presented, include any associated cost with moving a feed ground. With that, Mr. Chairman, I would stand for any questions. If there's no questions, I'd ask for adoption of Standing Committee Amendment number 1 to House Bill 101.
All in favor of Senator Ellis's motion to adopt the Standing Committee Amendment number 1 to House Bill 101, please say aye. Opposed? No. Standing Committee Amendment number 1 to House Bill 101 has passed. Moving to the question. All those in favor of Senator Ellis's motion that when the committee of the whole rises to report that it do so with a favorable recommendation of House Bill 101, say aye. Opposed? House Bill 101 has passed committee of the whole. Our next bill for consideration is House Bill 104.
House Bill 104, Uniform Trust Code Amendments, sponsored by Representative Greer, an act relating to trusts, was referred to committee number 9, which returned a committee recommendation that it do pass. Ayes, Senators Anderson, Beitman, Cooper, Rothfuss, and Wasserberger. Senator Anderson, Chairman.
Committee of the whole, you have heard the reading of the bill. What is your pleasure, Senator Anderson?
Mr. Chairman, I move when the committee of the whole rises to report, it do so with the recommendation that House Bill 104 do pass. And to explain this great little bill is a great Senator Nethercott.
Senator Nethercott.
Thank you, Mr. Chairman. We have the third bill and a series of updates to our estate planning laws. This is House Bill 104, Uniform Trust Code Amendments. Very exciting afternoon for you at 4:30 to discuss amendments to Uniform Trust Code. What the bill really does is it provides primacy to those trusts located in the state of Wyoming that also may have foreign trust components to them, that the terms of the trust will be that this state's laws will dictate the terms of the trust, even with those foreign connections associated with the trust. There are other provisions in there that really just kind of update the Uniform Trust Code associated with the application of the duty of loyalty and other kind of conforming amendments to stay current with our Uniform Trust Code. Of note, on the very last page of the bill, the act shall apply to all trusts created at the time that we adopted the Uniform Trust Code in July 1st, 2003, when it was originally put into place. And with that, I'd stand for questions and ask for your favorable consideration.
Are you ready for the question? All those in favor of Senator Anderson's motion when the committee of the whole rises to report that it do so with a favorable recommendation of House Bill 104, say aye. Opposed? House Bill 104 has passed committee of the whole. Our next bill for consideration Our next bill for consideration is House Bill 150. We read in the bill, please.
House Bill 150 engrossed, State Budgeting and Expenditure Authority, sponsored by the Appropriations Committee, an act relating to public funds and administration of government. Was referred to Committee number 2, which turned to committee recommendation that it do pass. Ayes Senators Guru, Hicks, Kinsky, Perkins, and Steinmetz. Senator Perkins, Chairman.
You've heard the reading of the bill. What's your pleasure, Senator Perkins?
I move the committee of the whole rise and report to do so with a favorable recommendation on House Bill 150, which is State Budgeting and Expenditure Authority. And for an explanation of the bill and the amendment, there's an amendment as well. We turn it over to Senator Guru, if you would, Mr. Chairman.
Senator Guru.
Thank you, Mr. Chairman. Yesterday, if you recall, I brought you House Bill 150 and walked through an explanation of the bill and the issues associated with that bill. It's the State Budgeting and Expenditure Authority. As you recall, that this bill makes some significant changes to spending authority with the executive branch and duties of the legislature. As we were walking through some of these issues, like the emergency funds issue, the B11 issue, and then the acceptance and expenditure of federal funds issue, most particularly, questions arose with regard to the new batch of federal funds that should be and are coming our way, and what this piece of legislation would have to do with those. The good senator from Bates Creek brought up a number of questions, and so we laid the bill back to today. So here we are. That brings us to the moment. And the options and the questions that were asked regarding this and these federal funds, we consulted with staff and consulted with our own appropriations team. And what we have done is, after listening to those questions and hearing those concerns, talking to the body, talking with staff, we have prepared a committee of the whole amendment, which I would like to have read in at this time.
House Bill 150, Committee of the Whole Amendment number 1 to engrossed copy, page 11, line 8 after.
And Mr. Chairman, to explain the amendment, I call on my fellow appropriations member, Senator Steinmetz.
Senator Steinmetz.
Thank you, Mr. Chairman. Well, as you recall, the good tall senator from Natrona County brought up the fact that we were able to receive and expend funds, but were we able to refuse funds with the latest batch? And that had not been contemplated in this bill. So, fellow senators, what we're doing here, the bulk of what we're doing is on page 13, line 2. And we're basically saying that the governor's office shall notify the legislature as soon as practicable of these funds arriving. And then we're putting some limitations on what occurs. The state is obligated, if we're going to expend more than $1 million in a biennium, the governor's office shall request legislative action provided by 94206. And if you'll remember, fellow senators, that is found on page 20 of your bill. And that's where he notifies the legislature that these funds have been received. And then the Joint Appropriations Committee has 10 days after they have received the request, and they get to vote on whether to recommend to the legislature whether we should meet in a special session or allow him to accept and expend the funds. And then we recommend that to the legislature, and the presiding officers of each house takes a poll of the legislature. So it comes back to you guys for a decision there. There is a little bit, I'll just be quite frank, we don't know if $1 million is the right number or not there. So I'd throw that out for your consideration. of course, asking you to adopt this amendment today. And then if we want to revisit that number, then we can do that as we move this bill along in the process. What we're trying to do then on the next page of your amendment is say that if the state's taxing or appropriation authority is in any way, in any manner limited, the governor's office shall request legislative action as provided by the section I just talked to you about, and shall not accept the federal funds until the requirements have been met. And so, and then there's an exception, except that the governor may accept federal funds as necessary to preserve the health, safety, and or welfare in accordance with paragraph III, which we've gone over before. So, and that constitutes a public welfare emergency where the public's health, safety, or welfare is in danger there. So that is the provision we've made in this amendment to help this bill along in the process. And so I'd stand for questions at this time.
Senator Scott.
Mr. Chairman, I want to emphasize the seriousness of the need for this amendment. Mr. Chairman, we've had to put up for a number of years with these maintenance of effort requirements on small parts of what we do. And they have been quite a problem to deal with. It's never been large enough to cause us horrendous problems, but it has been a problem. What's happened is in the stimulus bill that just passed, 2 weeks ago, the maintenance of effort has become much more widespread. We're trying to deal with the one in education, which passed while we were debating the bill, the recalibration, Senate recalibration bill here on the floor. That one is such that my calculation was that if we didn't change our laws successfully to deal with it, the consequence would be in somewhere between 3 and 5 years, we would have a deficit in the school funding of $450 million. Now, I was told by LSO that it'd be a 30% of the annual figure deficit would be what they could spend on schools. And that is $450 million. The consequence of that, just to put it in perspective, if you were to deal with it, and it would be because our reserves were down to a point where we couldn't afford to use them in education anymore. If we would deal that strictly with taxes, that's 3 cents. 3 cents additional on the sales tax, or between 20 and 25 mils on the property tax. And you can see what kind of a devastating impact that would have on our constituents and how they would feel. You can predict how they would feel about it. I think we would probably both, under those circumstances, tax them so much that they would be good and mad, and cut the services so much they would be good and mad. And the problem is compounded by this maintenance of effort requirements for higher education. There's maintenance of effort requirement for a good part of the health programs. You're starting to talk about a majority of our budget that we've lost control of. If we just, take the bait that's on the front of the hook and ignore the hook behind it, which is what I think the feds would like us to do. So this is a very serious issue. I think the amendment is a good start. I do have a couple of questions about it. One, in education, the money comes not to the governor, but to the state superintendent, who is independently elected and not under the control of the governor. Whether under our laws the governor has a say in that, I'm unclear. And my question is, does he, or do we have to include the state superintendent in the amendment? My further question is, would we, on second reading, maybe need to refine this a little bit to say that where a maintenance of effort was within an appropriation we had already made, that was all right, but where it either goes in time beyond what we've appropriated for, or exceeds what we've appropriated for, it ought to be made only with our consent. I've got some questions on that and some, like a little better explanation of exactly how this would work. At what point would legislative consent with this amendment be required? And I'm a little unclear in the mechanism, even after trying to read the amendment. It's complicated enough. But I can't emphasize to the floor too much that this is the largest attempt I've ever seen from the federal government to turn the states into just vassals of the federal government and just agents doing the will of whoever happens to be in power in Washington with no control over our own spending and taxes. That's, I think, the risk in what's going on with the extreme level of restrictions that the feds have placed in this particular stimulus. And we're trying to figure out how to tame the education one down. And frankly, I am uncertain as to whether we'll be successful, because they've done a pretty good job of tying things up.
Those in favor of Senator Perkins' motion to adopt Committee of the Whole Amendment number 1 to House Bill 150, please say aye. Those opposed? Committee of the Whole Amendment number 1 to House Bill 150 has passed. On to the question, or on to the bill. Senator Scott.
I do have a couple of questions as to whether we ought to include the state superintendent. And I am now uncertain of the mechanism we're actually using to get legislative consent and the circumstances under which it would be needed.
Senator Steinmetz.
Thank you, Mr. Chairman. So I'll try to answer a couple of those. I don't know about the superintendent. I think we need to check on that. So that's a good question. And I do think the federal funds probably flow through a central nexus, but I'm not sure how that all works. So we'll have to find that out. On page 10, it says no federal funds in excess of amounts approved by any legislative appropriations of this act may be accepted or expended until the governor is approved by the governor in writing. And so that's how they normally flow through now. And then we're putting the restrictions on and inserting ourselves into the process if it's not, if it hasn't been appropriated for a certain program, or if it doesn't have a specific federal use, then we're inserting ourselves into that process because we are concerned about where those funds might go. And not that this governor hasn't worked with us on the CARES Act funding, because he certainly has, and he's been a great partner in all of that. However, it is anticipated that in the future that might not be the case, and there is an attorney general opinion floating around out there where that was not the case. So if they're not restricted by federal or state law, or if we haven't specifically appropriated them, then this bill would come into place.
Ready for the question? All those in favor of Senator Perkins' motion that when committee of the whole rises to report that it do so with a favorable recommendation of House Bill 150, say aye. Opposed? House Bill 150 has passed committee of the whole. Our next bill for consideration is House Bill 107. Will you please read that in?
House Bill 107 engrossed retirement system efficient disbursement method, sponsored by Representative Henderson, an act relating to the state retirement system. Was referred to committee number 2, which returned to committee recommendation that it do pass. Ayes Senators Guru, Kinsky, Perkins, and Steinmetz. Excused Senator Hicks. Senator Perkins, Chairman.
You've heard the reading of the bill. What's your pleasure, Senator Perkins?
Mr. Chairman, once again, I ask that when the committee of the whole rise and report it, do so with a recommendation of do pass on House Bill 107, retirement system efficient disbursement method. Mr. Chairman, I'll go ahead and explain this bill. This little bill came before us, and ultimately, it's the concept is pretty simple. If you go to the bottom of page 1, top of page 2, it just provides the state auditor may approve an alternative to the use of warrants drawn by the state auditor for the disbursements of retirement system benefits, provided that the Attorney General reviews legality of the alternative. And then you go to the middle of page 13, and also again, as they're paying with respect to these warrants, are using appropriate alternative method approved by the state auditor. And then finally, you see again some conforming language again on the middle of page 3 about this alternative method. Again, on page 4, again, this alternative method, also at the bottom of page 4, at the bottom of page 4 and top page 5, alternative method. Mr. Chairman, members of the Senate, this as was explained to us in committee, and the state auditor was there to testify as well as the sponsor. Just the Wyoming retirement system is looking to save some money. Currently what you have is the Wyoming retirement system moves money to a bank so that they can do this disbursement of the retirement system. Then some of the money moves back later on. And so with that, there's about 30 days of interest, 12 on going one way and about 18 going the other way. There's about 30 days during the course of the year that if they can find a better alternative disbursement method that the auditor approves, could save them maybe $50,000 a year in expenses. So that's what this is about. No, that alternative distribution method has not been determined yet. Right now, the savings comes that this function is performed in large part by the Division of Administration and Information, A&I, and through the statewide cost allocation system, where A&I provides these services to agencies throughout. The particular cost for this is about $50,000 more than what the retirement system thinks they might be able to do it for themselves. And so this would end up being through a third party. If it's ever approved, it would end up to be through a third party dispersing agent that might be able to do that a little more effectively. However, that $50,000 in savings to them will not result in probably $50,000 of savings to the state overall. But nevertheless, the auditor is in charge of all that. This is an opportunity to, if somebody finds a distribution method that is as secure and as traceable and as transparent as the one we now have, it would allow the auditor to move in that direction and authorize the Wyoming retirement system to make those warrant distributions in this alternative distribution method. And so that's what this amendment does. Like I say, it's effective now, but nobody has a plan now. There's not any proposal before the state auditor for this to be done yet, but it just paves the way if they can find a better mousetrap to do this with, that it would allow them to move forward with it. With that, that's about all I know about this bill. So if you've got questions, I'll try to answer them, but I've told you about everything I know. Thank you, Mr. Chairman.
Are you ready for the question? All those in favor of Senator Perkins' motion that when committee of the whole rises to report that it do so with a favorable recommendation of House Bill 107, say aye. Opposed? House Bill 107 is passed committee of the whole. Our next bill for consideration is House Bill 217. Can you read that in, please?
House Bill 217, Community Health Center and Rural Health Clinic Grants, sponsored by Representative Wilson, an act relating to public health and safety, was referred to committee number 10, which returned a committee recommendation that it do pass. Ayes, Senators Baldwin, Bouchard, Furphy, Hutchings, and McEwen. Senator Baldwin, Chairman.
You've heard the reading of the bill. What is your pleasure, Senator Baldwin?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, it do so with a favorable recommendation on House Bill 217. And for explanation of the bill, I give you to Senator Bouchard.
Senator Bouchard.
I'm sorry.
Sorry, Chairman, I wasn't ready. Let me pull up the bill, Mr. Chairman.
What's that?
What bill's it? Why'd you let that happen to me? Thank you, Mr. Chairman. What we have here is a bill on community health centers. What we're doing here with this bill is we're just trying to make sure that there's a process in place. So that way, if there's grants available, and especially from private grants, not necessarily.
Could we read in the bill, please?
You did move. You did. Hey, thank you, Mr. Chairman. What we're doing with this bill is we're making sure that there's a process available to take grant money. I do apologize, members, I'm looking for my notes. Actually, I had the bill, but there's several processes that a community health center can take in a grant. And I'm just gonna work off of memory, forget my notes. So let's just say there's $14 million that's available for equipment or anything that a community health center could use. They could take that private money and using this grant. So this had a sunset that we're making sure that we're putting back in place, or we're taking the sunset out, I should say. So that way this stays available for the community health centers. So to give you an idea, it doesn't matter if it's here in this county or even in the rural counties, there's over 30 community health centers that could make use of this. So this is not about spending government money, although don't get me wrong, if there is some way that they need something, it could be a government grant as well, but that's not what this is about. This is about keeping things going. So there is a process for them. And I want you to think about what happens at these community health centers. So many of them, they work for a part of our society that won't walk in to let's say a hospital or even a normal doctor's office. Sometimes it's the homeless community that is getting care. So I'll go over a little bit of the bill here. On page 2, you can see starting line 5. There, it talks about the award grants in accordance with this section. As we go on to page 2, line 16, any grants provided by the department under this section that are funded in whole or in part with the state funds shall be subject to the following. It has pretty much all the provisions. As we go on next page, we've added costs and equipment costs. Equipment costs are a vital part to these community centers. Sometimes they're not able to buy a piece of equipment unless there's a grant to provide that fund. That's really the simplicity of the bill. And I'll stand for any questions.
Senator Hicks.
Yeah, Mr. Chairman, could we get a little explanation on section 2 of what the repealers do in 92127D subsection 6 and the repealer on section G? What are we doing with the repealers?
Senator Bouchard.
Thank you, Mr. Chairman. That is the sunset provision that's in the statute. So that was part of the process of this bill here. And understand this section, this has been used one time. So I believe if I'm trying to remember the amount, but there was one time we used, I think it was 2011 is when we used it. And it's never been used since. So this was about to sunset out. And all we're trying to do is make sure that there's a grant process available to keep these community centers whole. And this is not taking any general fund money. There's nothing, that's not what this is tied to.
Senator Hicks.
Mr. Chairman, I see that G is the repealer of the sunset, but when you get to 92127D subsection 6, that actually comes in and it says grant applicants shall provide proof of designation as a rural healthcare clinic or federally qualified community health center. Why are we repealing that provision that requires them to certify that they're an eligible entity?
Senator Baldwin.
Well, thank you, Mr. Chairman. To answer that question is we're just setting that back in repealing that the federal qualified health centers and the rural health centers are actually separate entities. We wanted to make them both available and this opens them both up. They have to qualify. They have to have surveyors come in and certify them. And we didn't need to certify that actually in this to open up the grants. Because I believe the answer, I can get you more of an answer if you need that. But that's the basic answer. They have to qualify. In order to qualify or to get these grants, it wasn't necessary for that to be in there to qualify for the grants. These grants originally came as federal grants, actually is where their money originally came from. And there's a number of, and we can't say those names on the floor, of course, but there's a number of grants available to bring things like the defibrillators that we have back here on the fridge. A number of those kind of things that come in from all these separate, that don't require that those are certified. That's why it's there. This is focusing on the private things that come in. They don't require that.
Are you ready for the question? All those in favor of Senator Baldwin's motion that when the committee of the whole rises to report that it do so with a favorable recommendation of House Bill 217, say aye. Aye. Opposed? House Bill 217 has passed committee of the whole. The next bill we have for consideration is House Bill 133. Can we have that read in, please?
House Bill 133 engrossed online sports wagering, sponsored by Representative Waters, an act relating to online sports wagering, was referred to committee number 2, which returned to committee recommendation that it do pass amended. Ayes Senators Guru, Hicks, Kinski, and Perkins. No, Senator Steinmetz. Senator Perkins, chairman.
You've heard the reading of the bill. What is your pleasure, Senator Perkins?
Mr. Chairman. Mr. Chairman, I move that when this committee of the whole rise and report that it do so with a do pass recommendation on House Bill 133 online sports wagering. And for an explanation of this fine large bill, we would ask that you call upon the good senator from the Razor City.
Senator Wasberger.
Well, thank you, Mr. Chairman. I move, I guess we've already moved House Bill 133, but this particular bill is a bill that's been going on for years, for decades. Our citizens have been wagering bets with bookies, but also they have been online betting for years. And they can do so with their cell phone. They can do so on their computer. And essentially what this does is allow the Wyoming Gaming Commission to allow online betting. And then it also has a tax to it of 10%. And so I will walk you through the major portions of the bill. It requires eligible events and individual statistics to wager on. So those things that you can wager on are like professional sports, the Olympics, international, college. You can even do electronic sports or esports. And any event approved by the Gaming Commission. It prohibits events where the majority of participants are under 18 years of age. So anything that's in our WHSAA is not allowed to be wagered on. And so in order to place a bet, it has a limitation of 18 years, which is comparable to the rest of our statutes. And so eligibility for an operator's permit, that is the corporations, the businesses that do the wagering. An operator that operates online sports wagering in at least 3 US jurisdictions. And then it also allows for our tribes to be a part of this. The number of operator permit holders, we have a minimum of 5, not to include the Northern Arapaho tribe and the Eastern Shoshone tribe of the Wind River Reservation, which are each eligible for licenses subject to the number of applicants. There is a temporary permit in the bill, which allows applicants vetted and in good standing in other comparable US jurisdictions to launch without delay. And so there is a 10% tax on this, and that money is actually going to the general fund. And so every time there is $500,000 in that fund, it tips over to the general fund. Those organizations that can be permitted or have licenses, an operator can have an application, and the application costs $2,500 and the renewal is $2,500. Initial permit, the very first permit is $100,000, and that's valid for 5 years. And then renewal on that is $50,000, and that renewal lasts for 5 years. The vendor, actually, the initial permit is $10,000, and that's valid for 5 years. The renewal is $5,000, and that's also valid for 5 years. Who regulates and keeps track of all this, creates the rules and the rulemaking and regulates it afterwards would be the Wyoming Gaming Commission. And essentially, administrative costs are subject to appropriations covered by operator and vendor permit fees. And on a quarterly basis, the Gaming Commission must transfer any amount from the permit fees in excess of $500,000 to the state treasurer to the credit of the general fund. And the effective date actually goes into effect July 1st, but you will see a standing, I believe it's a standing committee amendment to change that to September 1st. And at that time, I would ask that we take up the standing committee amendment.
House Bill 133, Standing Committee Amendment Number 1 to engrossed copy, page 24, line 6, delete.
Senator Perkins.
Thank you, Mr. Chairman. I'd move Standing Committee Amendment number 1 to House Bill 133 and ask for the Senate's favorable vote on this. What this was in discussion and in with testimony from the director or the commissioner, the executive director of the Gaming Commission. As we look at that, they need us. They're trying to get the 5 months it takes to promulgate the rules to do this. And with the session coming late and the bills coming late, the normal time frame doesn't work. So ultimately, this still puts them on a pretty tight time frame, but they believe that if they worked hard, that they could reach this. But this just gives them the ability to promulgate the rules. And Mr. Chairman, as you see the nature of this bill, it's very broad. And most of the blanks are going to be filled in, and most of the specifics are filled in by the rules. And so it's not just it's not a menial task or a minor task to generate these. So this is just in the abundance of caution to make sure that's done right. This is what this does, and ask the body to vote aye.
Are we ready for the question? All in favor of Senator Perkins' motion to adopt? Senator Kolb?
Thank you, Mr. Chairman. A question to the good senator with the very expensive beef. How do you envision the control over the persons that might participate to make sure they are over 18 years of age? Thank you.
Senator Wasserberger?
Thank you. That's the next. We're on the standing committee, isn't it? I'll answer that.
Once again, all those in favor of Senator Perkins' motion to adopt Standing Committee Amendment number 1 to House Bill 133, please say aye. Opposed? Standing Committee Amendment number 1 has passed. Let's move on. Senator Wasserberger?
Mr. Chairman, thank you very much. I will answer the question from the good senator from Sweetwater County. The system is called Know Your Consumer, or KYC. And how it works is actually works through satellite system. So if you place a bet with your phone, you get your cell phone, or you place it with your computer, it triangulates to your device and then can tell you who that is and what age that is. So I guess a person could be underage and place a bet on his dad's phone. But that's how they do it. And that's called the Know Your Consumer system. And it works very, very well. It's highly tech system, but that's how they do it.
Senator Giroux?
Thank you. And to further illustrate what the good senator was talking about, if you direct your attention to page 9, line 8, you'll see it says sports wagering vendor. Means a vendor that provides services to a sports wagering operator that the sports wagering operator uses to accept online wagers, including geolocation systems, the Know Your Customer services, payment processing, data provisions. So all those things are handled by a separate vendor who works, who is different from the operator, the one that's handling, that's actually running the sports betting operation. This vendor is to take care of all those ministerial details of taking the bet, processing the bet, making sure the bet's being done by a person of age, and that they're doing so at the right location.
Senator Hicks?
Mr. Chairman, I have one question on page 22, and you go to subsection B, and this deals with the penalties if you don't have a permit. And I'm curious in the language in here. I think I know what it's trying to do, but I don't know if the language actually gets there. So just some clarification. So it says when a series of similar events result in a violation under this chapter or commission rules, those events that occurred within the same month, and that's the part I don't understand, shall be treated as one offense and not a separate and distinct offense. I understand you could have a situation where you hit in any one day we're betting on a particular event and you could have multiple violations, but why the whole month period there is all considered just one offense? I don't understand that.
Senator Wasserberger?
Mr. Chairman, I wanted to check, are we talking about page 21, lines 14 through 19? I'm working with the engrossed. You've got the engrossed.
It's 22, line 4, subsection B. And then if you get down to line 6, it says that you could have multiple infractions of not having a permit, but you could go on for a month during a whole entire month's period of time, and it would only be treated as one infraction. I just trying to understand why we would allow that to happen for a full month. I understand a single event. So if there was somebody that didn't have a license, took multiple bets, maybe hundreds or thousands would arise, that would be one offense. But what happened if they did it the next week, and then the next week, and then the next week? The way I read the bill as it's currently constructed, that would still result in only one violation of not having a permit. And so I'm just trying to understand that. I'm sure there's probably a rational explanation, but I can't figure it out what it is at this time.
Senator Wassenberger.
Thank you, Mr. Chairman. And I don't have an answer for that, and I will have to get back to you on second reading.
Senator Perkins.
Thank you, Mr. Chairman. Just to wade in on that. So if you look at the offenses, and keep in mind, these are this is over regulated activities. And so for a first offense, you have and this is for people who are in regulation, so they're regulators, but otherwise they're out of compliance. So the first offense is $25,000, and the second or subsequent offense is $50,000 or civil. And so it's just, I mean, it's a policy decision. It doesn't have to be, but it just is, or say whatever. You're just saying, instead of we're going to aggregate, and so every time you did that, it's a 50,000, 50,000, 50, or 25,000, and then 50,000, 50,000, 50,000, 50,000 for that whole week. It's just, that month is going to be aggregated. Now, there's nothing magic about that, but that's just an effort to do that. But the other point that it's important to make, Mr. Chairman, is if you don't have a license, you're not permitted, and you're not regulated, this is these fines. It's not, not only are you in violation of this, but you're also in violation of the criminal code. And so for the people who are not coming into the system and doing this outside the realm of this commission, which there's a lot of that going on right now, because it's not regulated in Wyoming, that's technically illegal. And so if you catch those people, they're charged under the criminal code, under the gambling statutes. And so that we don't have, there's no additional penalty, because that's just illegal gambling if they're outside of that. So you may agree with that policy, you may think it's too stringent, you may think it's too lenient, but that's the basic idea behind the policy, as I understood it. Thank you, Mr. Chairman.
Mr. Chairman, I've got a couple questions in this bill. First, there's taxes in here, there's penalties in here. Suppose fly-by-night unlimited based outside our jurisdiction, some other state or even some other country, markets this online, does business with Wyoming customers, doesn't pay any of the fees, taxes, or anything else. They're illegal. But what chance have we ever got of doing anything about it? Is this just going to be ignored by the competitors, the legitimate people, and cause us to not be able to regulate it and just contribute to illegal gambling?
Senator Perkins.
Thank you, Mr. Chairman. And I've had a lot of these same concerns, and I actually have an amendment being prepared for second reading that will bring, and if it passes, would require the commission to set up compliance programs, both to make sure you're complying with the regulations that so if you're being regulated but you violate the regulations you're under, there's a compliance program for that, but also the compliance program for those who are skirting around and basically, if you would, the black market, the people who are avoiding this regulation. And so it'll do that. I've been down to visit with the Attorney General. We've had a little visit about how that might look in the future. someone will do that. But the other thing that's important to remember that when you're violating these statutes, if these states and it's illegal in these states and you're doing this obviously across state lines, it's also a federal offense, is my understanding. It's also a federal offense. And so the feds are on that too. There are joint task forces that are working on these things. And so there's not just the opportunity to, and the reach of law enforcement within the state, but there's also cooperation going on with federal agencies on these same issues. And so we don't understand it all yet, and we'll have to figure out how to get this in. That's why one of the reasons I'm going to bring this amendment tomorrow is to make sure we get a good look at that. But ultimately, it is not just us trying to rail at the wind and catch the evildoers. It will also be United States agencies that overlook this as well.
Chairman.
Senator Scott.
Mr. Chairman, if we do not pass this bill, am I right in thinking this current state of the law is that this is illegal gambling? And has there been any effort to enforce that law? Because I'm afraid we're in the same boat as if we were dealing with somebody who's violating it. Nobody's enforcing anything. What's the situation if we do not pass this law? And how does this law help us deal with the illegal things that are going on?
Senator Guru.
Thank you, Mr. Chairman. That's I think one of the essence of the bill and why I'm very supportive of it. When you have an operator and a vendor working together that's regulated by the state, which this law brings to the state, the betting public will want to go to this site to bet because it will be a safe place to bet. And you're absolutely right. Today, you can pick up your phone right now and make an illegal bet on a game that's occurring tonight. You can do it. They're offshore companies. You deposit money in and you make a bet. Well, let's say there's a big game coming up and there's a 10-to-1 bet and you put $50,000 down and you win. You win $500,000. Then you go to this vendor and say, I'm ready to collect, and no answer. With this bill, you'll have redress. You'll be able to go to the gaming commission and talk about the problems that occurred and that you were wrong. With these illegal sites that are operating today, you have no such protection. That way, the gambling public will want to go to the sites that are regulated and are held by the state and regulated by the state of Wyoming or our tribal partners as well. So they'll be able, that's the safe haven for you to do this and do it legally. And that therein will be the protection there. And then of course, with the vendors having the geo location sites and making sure that the people that are betting are of age, there's more protection. And as long as I'm here at this time, I have a committee of the whole amendment that I would like to have read in at this time.
Will the reading clerk read in the amendment?
House Bill 133, Committee of the Whole Amendment Number 1 to engrossed copy, page 19, lines 20 through 23, delete.
Mr. Chairman, I'd like to move Committee of the Whole Amendment Number 1 to House Bill 133 and ask for your favorable consideration. If you'll look at the amendment, it starts on page 19 and it goes from lines 20 to 23 and deletes, and then on page 20, deletes lines 1 through 6, and also does some renumbering on page 20, line 8. Basically, with the Committee of the Whole Amendment, we set up a time frame for regulations to be written and promulgated by the Gaming Commission. What this amendment does is take out the temporary permit. We have a time frame. We have a time frame for the legal operation to begin. This takes away the temporary permit because now it's been deemed, I feel it's unnecessary to have that. This has been also given in consultation with all the players that are involved in this, and all agree that this is an appropriate amendment. So I ask for your favorable consideration and stand for questions.
All those in favor of Senator Perkins' motion to adopt Committee of the Whole Amendment Number 1. All those in favor of Senator Guru's motion to adopt Committee of the Whole Amendment number 1 to House Bill 133, please say aye. Opposed? Committee of the Whole Amendment number 1 has passed. Back to the bill. Senator Ellis.
Thank you, Mr. Chairman. I've heard it referenced a few times in the discussion of the bill that somehow we've incorporated or recognized our tribal counterparts. And as I've looked through this bill, I don't see that language specifically identified, and I'm trying to track the digest and see what happened. My understanding is that some language was added, then perhaps removed. And so I just want to make sure, because I don't see any reference to either the Northern Arapaho or Eastern Shoshone tribes in this bill. So if I'm mistaken, please let me know.
Senator Wasberg.
Mr. Chairman, thank you. And we're very accepting to an amendment to accept and to partner with the tribes in our state that already have been allowing gambling for many, many years. And so if the good senator from Laramie County would like to bring an amendment to do just that, we would accept it as a friendly amendment.
Senator Schuler.
Thank you, Mr. Chairman. I just need just a little bit of a clarification. If I've read through this bill and understand it completely, and maybe I don't understand it completely, but so it sounds to me like that, because I've heard that there's online, sports betting going on already. So these folks that are doing this right now illegally, we're not capturing any money from that, any tax at all. But somebody somewhere, an operator maybe in another jurisdiction is, and their state is. So I guess the question I have is basically this bill kind of brings it out of the shadows. It puts it underneath the gaming commission, makes it legal, and it also helps our general fund by putting 10% of the tax into our general fund. So am I reading that right? Is that what I'm getting out of this? Thank you.
Senator Perkins.
Thank you, Mr. Chairman. And I think that's exactly right. There's two things that are going on there's two things going on in Wyoming that this bill, and if it passes, would correct. It would be, one is there's this illegal gambling that happens mostly from offshore and other places like that. And so if you don't have somebody to kind of help with that compliance and help identify that and then partner with other states and the federal government to try and curb that, that continues to happen. The other thing that happens is, and I talked to one just 2 weeks ago, he, when there's a game coming up or when he's ready to do this, or when he's getting ready to do his sports fantasy every week, what he does is he just gets in his car and he drives 11 miles south, and then his geo tracker picks him up, and he's doing it legally because he's doing it in the state to the south. And so then he drives back home to the capital city here and sees how he did later on. And so that's the other side of it is we have, particularly just like it was before with lotteries and things like that, there are people who migrate out of the state and place those bets, and then they just come back to the state and do that. And so this is already happening both legally and illegally now. And this helps in large part. A big part of this bill is not necessarily to create a hammer to go after those who are doing it illegally, but to create a more protected and regulated environment. So when they place the bet and they win, that their bets are paid, that the odds and those things that are done are they're paid out in accordance with those things, that the money and your winnings are not absconded with, and so. And you provide those consumer payouts. Now, the competition between all these varying things is, they'll adjust their payouts, and you get to kind of go bet, among these competing online gambling sites and fantasy sports and things like. You go out to these things, and you'll go. They compete for your business, and they compete for it legally. But nevertheless, I mean, this is, like I say, this is something that's happening in Wyoming both legally, and our citizens are doing illegally, and then our citizens are doing legally by simply going across the state line. And literally it's, if I go to the state line, if I go here and place my bet, I'm legal. If I go here and place the bet, I can't place the bet because the geo tracker says, oh, you're in, well, I probably need 6 feet between where I just stepped to make sure the satellite can pick it up. But, that's what's happening in the state right now. So I think that the answer to the good senator from Evanston, that's what I perceive and what I learned from hearing the testimony on this bill. Thank you, Mr. Chairman.
Senator Wasserberger.
Well, thank you, Mr. Chairman. Actually, that is exactly what the good chairman of appropriations said is exactly what the bill does. It tries to stop the black market that's taking place now, put consumer protection to the bill, and then allow people in Wyoming through what's called the Know Your Consumer System and geolocation tracking to place bets. And then it has a 10% tax on that bet. It is thought, actually, the companies that actually do this, and you can put an app on your phone and just press your app and make your bet. But the companies that do this stated that last year in Wyoming, there were 138,000 bets placed in the state of Wyoming by different people. And that the total was $449 million. And we, if that is correct, and that's what this does in the very first year, then we anticipate about $500,000 from that. So it also puts in all consumer protections for the person who makes the bet. It requires that the person who makes the bet have an account with them and money is in that account. It tracks the number of bets that that person makes. And if that person is deemed to have a problem in that, then there's money set aside to help them in various different ways. And so it really does protect the consumer. And we have gambling now, and we have people in our state doing this now to an extent. And I can honestly tell you that I have never placed a bet ever in my life. I've done handshakes with people and bet on different things, but I have never done a bet this way. And I don't plan to, but I do believe, and I've watched a lot of my friends do this. They bet all the time, but they make a lot more money than I do. And I don't like to risk my money that way. I like to have really big bull sales with high priced bulls is what I like. That's what I really like. But that was actually my son. So I believe that the bill, it's kind of a voted up or voted down. We really don't do anything about people who do online gambling because we can't stop it. But we do have a Wyoming Gaming Commission that we created. We have gambling now. We have people doing it, and we might as well protect the consumer in the ways that we can. And so I would ask for your favorable vote on this bill.
Senator Ellis.
Thank you, Mr. Chairman. I think to quote our former colleague, Senator Coe, I'm sitting next to Senator Wiesenheimer. I'm sorry, we just haven't heard that once this session. My apologies, privilege of the floor. But back on the bill, we did create this gaming commission, and one omission I see from this bill are just a little bit more kind of the things that we've been dealing with after the fact in the skills game arena. As the bringers of the bill discuss, these sports waging operators have to apply to the commission. But what happens if they deny it? Do they get a hearing? Do they have to comply with the Wyoming Administrative Procedures Act? And then kind of along those lines, it talks about a review of the criminal history, but we don't really outline what might be some grounds for denying an application. I'm guessing we'd want to keep people who have backgrounds similar to what we discussed in the skills game discussion about, convictions involving crimes of theft and those kind of other things. So I just want you to, or just want to make it known that I do have a little bit more concerns about how some of these procedural things that will happen if the commission denies a permit. And so we'll perhaps work with the bringers of the bill to maybe clear that up and provide some consistency. But I think this just illustrates that this is kind of a growing industry in Wyoming. Our commission, we need some uniformity, and it's an important issue. So one that we'll be working on, I'm sure, to make sure we're getting it right in future years. Thank you, Mr. Chairman.
All those in favor, of Senate Guru's motion that when committee of the whole rises to all those in favor of Senator Perkins' motion, when the committee of the whole rises to report that it do so with a favorable recommendation of House Bill 133, say aye. Opposed? House Bill 133 has passed committee of the whole.
Mr. Chairman, I move the committee of a whole rise and report.
You have heard the motion. All in favor, say aye.
Aye.
Opposed?
Attaboy, Troy.
Can I keep this?
Reading clerk will read in committee of the whole report.
Mr. President, your committee of the whole, having had under considerations bills on general file, begs leave to report as follows. House Bill 64 engrossed, do pass. House Bill 112 engrossed, do pass amended. House Bill 68 engrossed, do pass. House Bill 79, do pass. House Bill 85 engrossed, do pass amended. House Bill 101 engrossed, do pass amended. House Bill 104, do pass. House Bill 150 engrossed, do pass amended. House Bill 107 engrossed, do pass. House Bill 217, do pass. House Bill 133 engrossed, do pass amended. Senator McEwen, Chairman.
Senator McEwen.
I move the standing committee of the whole report. Just committee of the whole. Report.
You've heard the motion. All those in favor say aye. Aye. Those opposed, nay. Mr. Majority Floor Leader, that clears the desk.
AM Friday, March 25th. Thank all of you. We're caught up and doing well.
Announcements. Senator Scott.
Mr. President, your committee number 4, education, will meet tomorrow morning at 8 a.m. in room W110 downstairs. The bill will be House Bill 173, school finance. The announcement says if introduced or referred, and it has been. So we'll be meeting on that. We'll get an explanation of the bill. We'll take public testimony. If we don't exhaust the public testimony, we may seek to extend the meeting later in the day if we can accommodate that with a quorum and find a place.
Stay in the neighborhood. Senator Nethercott.
Thank you, Mr. President. Your number 1 committee, Judiciary, will meet tomorrow morning at 8 a.m. in Extension Room 4 to hear the following 4 bills. House Bill 212, Expungement for Restoration of Rights. House Bill 236, Firearms Transactions Financial Discriminations. That's right, another firearms bill. House Bill 41, Intrastate Crowdfunding Exemption Amendments, and House Bill 43, Digital Assets Amendments. We will also meet upon noon recess to hear House Joint Resolution 9, Local Government Investments and Equities, House Joint Resolution 11, State Sovereignty Impacted by Federal Actions, House Bill 179, Optional Municipal Tax Election, and House Bill 65, Political Subdivision Deposits. That will be in Extension Room 6.
Senator Perkins.
Thank you, Mr. President. Mr. President, your committee number 2, appropriations, will meet tomorrow at 8 a.m. in the room W113 and online to take up the following bills and any referrals. The following bills are House Bill 142, Commercial Filing System Update, House Bill 197, Connect Wyoming program, federal funding, and a re-referral of House Bill 207, coal-fired generation facility closures, litigation funding.
Senator Baldwin.
Thank you, Mr. President. Your committee, Perfect 10, will meet tomorrow morning at 8 a.m. in room W6 in the extension, otherwise known as the Health Spa. We will be hearing House Bill 253, higher education ban on funding for abortions.
Senator Boner.
Thank you, Mr. President. Your committee number 5, agriculture, will meet upon adjournment today. So let's say at 5:45 in Capitol Extension Room W2 end online to consider House Bill 188, irrigation district loans, and House Bill 229, livestock identification choice act.
Senator Wassenberger.
Thank you, Mr. President. Your committee, Committee number 9, Minerals, Business and Economic Development, will meet on Friday, March 26, 2021, 15 minutes after noon recess in the Capitol Extension Room W004 and online to hear the following bills. House Bill 166 engrossed, utilities presumption against early facility retirements, and House Bill 170 engrossed, Wyoming economic development zones. Thank you, Mr. President.
Oh, thank you. Quite the announcement. Senator Driscoll, can you compare to that
Thank you,
announcement?
Mr. President, I won't compete with that. We'll just stick with the old monotone. Your elected committee number 7, corporations, elections, and political subdivisions, will meet on adjournment. Be 20 to 6 to take up in room W110 and online to take up a continuation. House Bill 198, University Water System. House Bill 75, voter identification if time permits. House Bill 163, federal congressional elections residency, and House Bill 187, elected official residency requirement.
Thank you.
That's no bull.
Thank you. Further announcements, there being none. You've heard the motion. All those in favor say aye. Those opposed, no. Senate will stand adjourned until 10 a.m.